Hey, welcome to Case Brief with Megan. Let's make this case brief. Now we've got a big hot topic for this particular case, and it's a little something called birth control. When we think of birth control, we think of the case Griswold versus Connecticut, but that's not what we're covering today, because Griswold versus Connecticut only covers a big portion of birth control laws, and we have another one here called Carey versus Population Services International. In this particular case, we are living in a post-Griswold society. It's the 70s. People who are unmarried are able to receive birth control. However, New York has new restrictions that they put in place that may cause a problem for people trying to receive birth control. The rules is that if you're under the age of 16, New York says you cannot buy contraceptives. There's no birth control, no condoms, no nothing. The rule that New York had in particular was that you could only get contraceptives through a licensed pharmacist. Finally, New York had this law that said that you couldn't advertise or display contraceptives to the public, so companies were out of luck there too. However, family planning and sexual health are still really important to some companies, so we have this one company called Population Services International that gets this bright idea to put contraceptives in a vending machine to make these more accessible to all. Of course, this is a big problem for New York, so Population Services ends up bringing New York State to court to say that this restriction that they have on selling contraceptives and who can access them is actually unconstitutional. This is how we finally get to the issue in this case, which is, can a state restrict who is buying contraceptives, who is advertising, and who gets access to contraceptives? The rule in this particular case is no, usually states can't restrict that sort of thing. New York is being unconstitutional with this rule. Where we get at everybody's constitutional right to privacy. It's a bit of a balancing test. So the federal government and the state can regulate certain products, but there needs to be a health and safety concern. And they can't make it unnecessarily difficult for people to receive products that they want to buy. If you want to buy something like alcohol or nicotine products, that's your responsibility, that's your say-so. This is something that we already kind of tackled before in Griswold versus Connecticut, which says that you can give contraceptives to both married people and unmarried people. The court looks at this and they say, look, the right to start your own family is one of the most personal decisions that somebody will make in their lifetime. The state is making it so hard that you can't get products to stop from creating a family. That interferes with your private decision on whether or not you want to have a family, and states just can't do that. That's one thing that New York brought up is they're like, we have this age restriction on 16-year-olds because if we don't give these products to 16-year-olds, that should drive down teenage pregnancy. And that's where the courts actually say, let's look at the science behind it. It's actually looked at scientific studies, which showed that decreasing or completely banning access to contraceptives from a minor group of people didn't stop them from participating in those activities. It just made teenage pregnancy a lot more likely. Where the courts kind of sat there and said, well, if they're going to do it anyway, we might as well make sure that they're being safe and allow for contraceptives to be sold to these people. State is also trying to do this thing where they're like, no, it's so unsafe to sell contraceptives unless you're a licensed pharmacist. This is also where New York kind of takes a stab at it and they're like, how unsafe are condoms really? And so New York kind of tosses that argument out the window. So that whole shindig that companies can't advertise their products, this is again, New York State is struck down. The federal courts actually say, they're like, hey, listen, people can't make informed decisions about what they're buying if they don't know that the product exists. Courts say just because you don't like the activity that would partake when we're selling these products doesn't mean that you just get to restrict their advertisement. If you learned anything from this case, maybe it's to start investing in vending machines. Yeah.